Everyone, we're gonna get started. Everyone, we're gonna start now. Thanks, everyone. My name is Kelly Dixon on behalf of the Santa Clara Law Federalist Society. Thanks for coming to our event. If you haven't come to one of our events, the Federalist, I'm going to give a brief introduction of what the Federalist Society is. The Federalist Society is a nonpartisan, conservative, and libertarian organization dedicated to freedom, federalism, and judicial restraint. The Federalist Society seeks to educate the legal community through its programs and publications about how limited constitutional government based on the rule of law can have a positive effect on law and public policy. And today we're have a discussion on antitrust law with Ashley Baker and Professor Polden. And I'm going to intro Ashley Baker. Ashley Baker is the the director of public policy at the Committee for Justice. Her focus includes the Supreme Court, regulatory policy, antitrust, and judicial nominations. Her writing has appeared in Fox News, USA Today, Boston Globe, The Hill, Real Clear Politics, The American Spectator, and elsewhere. Ashley is also the founder of the recently formed Alliance on Antitrust Coalition. She has testified before the United States Senate on the topic of antitrust law. Ashley is an active member of the Federalist Society, where she serves as a member of the Regulatory Transparency Project's Antitrust and Consumer Protection and Cyber and Privacy working groups. As a member of the Republican National Lawyers Association, she has served as a speaker on the Supreme Court and the federal judiciary. As an expert of the judicial nomination process, Ashley worked closely on the efforts to confirm Justices Neil Gorsuch and Brett Kavanaugh. And much of Ashley's work is at the intersection of the courts, regulation, and technology. Ashley also engages in policy analysis and outreach on legislation and regulations related to these issues by writing op-eds, letters to Congress for committee hearings and regulatory comments. And then our own Dean Emeritus Polden is a well-known scholar on this subject and has practiced federal antitrust law in both federal and state courts. He has also authored law review articles focused on federal antitrust and security law, and he's a contributing writer to the HuffPost. And so Ashley will start out, and then we'll have discussion between her and Mr. Professor Polden, and then we'll open up to Q&A. Thank you, and Ashley will start out.
Thank you. First, I'd like to apologize for I'm sorry I'm not there in person. I would have really loved to be there in person. I've been traveling most of the month, and I just came back about less than 24 hours before with a cough that was definitely allergies, but definitely also unacceptable on airplanes. I had to I sit this one out. But I was really looking forward to that. I'm sorry I couldn't be there. Actually, I looked for to make my virtual background the room that you guys are in right now, and for what's probably some very good security reasons, you can't find that online, which is a good thing for you guys. Thank you again for Kelly for having me. And I'd just like to start off by saying quickly, I'm going to give a quick overview, but first, I can't see the entire room, but how many of you have taken antitrust? Yeah, okay. That's about typical of our audience. I just, like to know kind of where the starting part is in terms of addressing a little bit of the background and the history. So I'm going to quickly go through the history, and then Professor Polden and I can also, indulge in a debate that's more related to what's going on today. So I'd first say there's never been a more exciting time to work on antitrust law. It's an area of law that's been pretty well settled since about 1977. It wasn't before then, but for a while after that, it was. But recently we've been seeing a ton of action in Congress and in the courts, and also on the state level as well. So now's the time to kind of address some of these big questions. And I know it's brought up that the members of this chapter are interested in kind of the big tech issue, and a lot of people are. By the way, I've never viewed antitrust as a big tech issue explicitly, probably because I've been working on it before as a big tech issue. My background before this was in finance, and I viewed it as more of a banking issue. I'm sure there are others who have viewed it as a tobacco issue and a railway issue, and it changes industries every couple of decades. But back to tech, the big question now is, what is the role of antitrust in the economy and our society as it relates to big tech? So not only does this debate present some interesting legal and economic questions, at the same time, today's antitrust debate underscores some interesting rifts within both political parties, and it serves as somewhat of a microcosm of broader political dynamics. Some of the questions that are framed around big tech are really much broader about the role of government versus private power, and particularly to what extent they should shape our markets and the economy. And today I'd like to discuss the recent antitrust proposals, as I said earlier, the history of the law and how we got there to where we are today, and the considerations over big tech. But first, I think it's always good to back up for a moment and to address the question that's posed by many now. And is big tech too big? And I think that gets to the heart of a lot of the antitrust debate. And it's one of the key questions. And of course, like most legal inquiries, this one leads to just a lot more questions initially. So to start out with, the obvious, how big is too big? On a basic level, bigness can be measured in users and valuation. However, some are more useful than others when lots of people have them. For example, the first people to buy a telephone, the earliest email adapters, and Tom from MySpace. I'm not sure how many people in this room still get that reference. I should not make pop culture references, probably. These people probably found these things more useful when a lot of people started, jumped on the consumer bandwagon. And then the more complex questions is, what are the consequences of having laws that rely on an arbitrary measure of bigness? Because that's a theme that we're seeing, in, particularly in this administration and in the overall debate, is this return to big is bad, to return to the 1960s to mid to late 1970s arguments that were being made there, and it's kind of like we're having to rewrite history or rehash what went on during that period. And I would say that the relevant questions of how big is too big, the relevant questions are: one, does it harm consumers or otherwise violate competition law in acquiring or maintaining a monopoly, as the court, for example, held in 1911 in American Tobacco? And two, which is a really big one in any policy area, is what exact problem are we trying to solve here in these proposals, especially when it comes to Congress, but also more recently the FTC as well. And that last question is an important one and is often ignored and can yield a wide variety of answers. So for decades, antitrust law was used with varying degrees of success as a proposed solution to very different problems, many of which are unattached to the competitive process. For instance, environmental concerns, income inequality, a myriad of other policy objectives. However, a legal system must be built upon laws that have specific intended outcomes that solve particular problems. The rule of law requires this very basic foundation. However, otherwise, law will be unpredictable, untenable. Eventually, it will serve too many masters. Antitrust has come to the point where people want one body of law to serve too many masters other than having one goal. And that was antitrust in the 1960s. So in the antitrust paradox, as I'm sure you're all familiar with, Robert Bork argued that Congress enacted the Sherman Act as a consumer welfare prescription, was the term that he used. So in short, Section 1 of the Sherman Act prohibits activities that restrain trade if those restraints are unnecessarily restrictive of competition in a relevant market. But here's the actual language of the Sherman Act, which says every contact, combination in the form of trust or otherwise, or conspiracy, and restraint of trade or commerce among the several states or with foreign nations is declared to be illegal. But really, under that specific plain meaning of the text, most things are illegal. Shoes sold in pairs, for example, but the courts long ago recognized that not every restraint can be illegal, because even a simple contract between two parties technically restrains trade at some level. That is exactly what a contract does. So this realization first occurred right after the Act's passage, and then during the area between about 1890 until about 1914. And it's something the courts really struggled with for the better part of the 20th century. Antitrust law was particularly rudderous in the mid 20th century. And then eventually, in the 1970s, court came to interpret the Sherman Act to only apply to unreasonable restraints. And in 1979, only a year after the Antitrust Paradox was published, the court explicitly acknowledged that the Sherman Act was enacted as a consumer welfare prescription. It's repeatedly acknowledged that through the decades. The consumer welfare standard, for those who are unfamiliar with the term and with that interpretation, but the consumer welfare standard uses economics to reliably predict when conduct is able to harm consumers as a result to harm to competition. It's broad enough to incorporate a wide variety of evidence and shifting economic circumstances, but also clear and objective enough to prevent being subjected to the beliefs of courts and to enforcers. And in doing so, this really, it honors the principles of the rule of law, and it serves as a guidepost for judges as well. It serves in a way as a guard against judicial activism. To kind of sum things up, today the consumer welfare standard is being undermined. There's a momentum to use it against big tech. It's very important to go back to the basic question of what problem we're trying to solve. So on the surface, it looks like there's bipartisan support to overhaul our antitrust laws. But if you look closer, it's more accurate to say that one side is attempting to take a sledgehammer to a bunch of misplaced pin needles, and the other side has a problem with companies that are simply too big. Any solution that both sides agree upon will do all these things. It's certainly not into work in the way that anyone hoped or would be expected. So if bigness is the core problem to solve, in that case, bigness is in the window for a desire to micromanage the entire economy and should be looked at with some degree of skepticism. Competition concerns can start with size, certainly. Analysis can start with size, but antitrust analysis certainly does not stop there. It doesn't entail merely counting the number of firms on one's figures. So rather than bigness, we should focus on the number of tangible factors, particularly harms to the competitive process that in turn harm consumers. The consumer welfare standard guides us. The relevant inquiry is, how did a big company become so big? And how is it exercising the power it has in its bigness in ways that constitutes anti-competitive conduct? And I mentioned that the consumer welfare standard is under attack, and by that I don't mean it's going to be directly overturned, so to speak. It's not statutory. That's one piece of confusion I get from those who have been taking antitrust. But current proposals such as shifting the burden of proof during mergers and acquisition cases, so to speak, that will make sure that it kind of dies death by 10,000 cuts. And this has really real world consequences. It has consequences for mergers and acquisitions and for venture capital investments and a lot of things. I'd just like to close out by saying, like, in 1999, modern day trust busters believed that a company that makes the internet browser controls the internet. 20 years later, and approximately 3 dozen web browsers later, no single company controls the internet, and a vibrant and competitive online ecosystem has transformed our daily lives. So in the end, good products win. And in the end, when good products win, good consumers win. I know I've gone over my time here. So it's hard to start with 1890 and cover anything in any good amount of time. I like to save that time for our discussion, but thank you.
Do you want to make remarks on that?
Absolutely. Ashley, thank you very much. I feel awkward here. I have my back to our guest in terms of how
You're fine.
You're suited on this, but thank you for the invitation to join you all and talk about this topic. Several of the points I wanted to make are very similar to points that Ashley had made in her opening comments. A couple of preliminary things about this. The concerns about the adequacy of the U.S. antitrust laws, they exist in markets or industries other than technology. And so there's great concern about the effectiveness of our antitrust enforcement in markets for healthcare, in markets for regulating pharmaceutical drug pricing, even in markets, agricultural markets, where there are concerns political concerns, cultural concerns about preservation of small farms at a time of increasing large-scale farming. So the antitrust laws are being asked to do a lot of different things in different markets. You have to remember that the antitrust laws, the U.S. antitrust laws, were written in 1890. They were designed expressly to address railroads, the dominant railroads, and also a number of product trusts, the alcohol trust, gunpowder trust, a few industries or businesses where they had tremendously coalesced. It combined through acquisitions and exclusion of competitors so that there were only one or two firms that were providing these products. They were like monopolies, or they were small groups of otherwise competitors who were combining together in terms of setting prices and restricting output. So that's our historical lineage. Virtually all of antitrust law in the United States is made by judges who are interpreting two statutory provisions, Section 1, Section 2 of the Sherman Act, which are very sparse. They prohibit, Ashley was saying, they prohibit restraints of trade, and they prohibit acts of monopolization, but without definition, without clarity in it. So that's been left to the federal courts for, well, since 1890. And so that's what we're kind of working on here. Serious scholars today in the antitrust area continue to be concerned about concentration in industry. Concentration where you have few sellers of a product that comprise a lot of the industry. Search engines. 4 firms control 98.5% of search engine searches. Wireless communications. 4 firms control 94.7% of the market. Soda products. Coca-Cola has 45% of that market. 4 firms control 93.4%. So there is this, and you can look at other industry, hardware and office supplies, big box stores, drug stores. They have gone from corner Main Street down to a few major national firms. Is this just an inevitable consequence of our economy, or is this then because of lax enforcement against the problems of highly concentrated markets? We worry about concentrated markets, highly concentrated market, because it's easier to collude. If you have 4 people that you want to agree on a price or restriction on output, that's much, much easier than doing 40 or 45 or 50 firms trying to get agreement on that. So more pluralistic industries, we think, are better, at least in our capitalistic system, but that has not been the movement or the trend, and we see this clearly in technology markets as well. So Ashley also mentioned correctly about what are the antitrust laws supposed to be about? Well, if you read the legislative history in 1890 of the Sherman Act, it was a whole bunch of different things. One of the biggest ones was the fear that economic power in the form of monopolies could spill over into political power. And so one of the concerns we have about monopolies is, what do monopolists do with their profits? Well, they use a lot of their profits, monopoly gain profits. Those are industries where prices are higher because there's less output, because it's controlled by a firm with dominant market power. So prices are higher, there's fewer goods in the normal monopolized situation here. So what do they do with their monopoly profits? Well, they spend a lot of them trying to maintain their monopoly. And one way to do that, one of the most effective ways to take your monopoly dollars, if you're a monopolist, is go to K Street, argument goes, and hire lobbying firms to try and erect protections around your industry, all 4 of you in having 90% of this industry to protect it. Those are economically wasteful, aren't they? I mean, most lobbying expenditures not particularly useful. We'd rather see it how? We'd rather see those profits in the form of reduced prices for consumers. Ashley brings up Robert Bork, a very controversial figure, who spun this idea of that the principal goal of the antitrust laws was the betterment of consumers. That's not really what Borkian, pardon that term, did I just make it up? No, I've read it someplace. There really is. It's about this came from Robert Bork, very a great guy, and most of us are familiar with his failed bid for a position on the U.S. Supreme Court, or largely for political, his views on constitutional provisions. But here's the thing about this: his concerns were really about producers, not so much about consumers. And so, if Bork saw a joint venture, like the NCAA is a joint venture, isn't it? 1,600 universities combined together, and they play against each other and they sell products. The NFL is a joint venture. So if you have a joint venture that combines together, and through their combination together, they're able, through efficiency reasons, to save $100, let's say, on a product. Bork and the University of Chicago perspective would say that's economic efficiency. And this is, in a national sense, a very positive thing. However, let's suppose that the joint venture saves $100 in efficiency, but it raises prices because of cartel price fixing or monopoly price fixing by $80. So you have a net efficiency gain of 100, but you have a negative loss to consumers who are paying higher prices. So the true proponents, Herb Holding-Camp and some of those that have looked at this conundrum here, this thing, they've more focused on the fact that consumers are paying $80 more rather than producers have saved $100 more that they can then put into their pockets. They can return to shareholders, that's a good thing. Or they can use it to maintain the power of their joint venture. So this is a thing that is generated a lot of controversy today, appropriately so, about really what's the purpose behind our antitrust laws. More efficient firms or lower prices for consumers. I have some specific comments about the tech area, but you want to get into that in questioning?
Yeah, start the first
Can I
question.
address like a couple of, make a couple of clarifications based on the professor's remarks?
Yeah. Go ahead.
Okay, I'll be brief. First of all, I'm not a lobbyist, not saying you're accusing me of one. Just let me put that out there. I'm using on the other side of these firms, and often I actually am on antitrust sometimes as well. I think the professor put out he put out a lot of good areas regarding concentration. Meat packing, for example, that there's a lot of concentration there. I think a lot of it also has to do with pre-existing regulations. As sometimes this does, it's a lot more complicated than just things that fit under the antitrust laws themselves. It's not saying that antitrust can't solve that. And in that industry specifically, there have been a lot of blatant Section 1 violations that were rightfully prosecuted. Hospitals as well, but also kind of a more complex regulatory issue, and sometimes even depending on the circumstances, issue. We're in search engines. I don't really view it as much of a problem. Therefore, the way I view it is innovation now. So if you're an entrepreneur, no one's really trying to necessarily build the next Google. Maybe one or two people are, but that's not where that community is headed. Like, so now firms they're not replacing vertically, so to say. They're kind of replaced from the side with someone who kind of comes in with a new product that's very different from the ones that exist now. As in terms of have we stopped enforcing antitrust And that's always a hard one to answer, you know, not being at the agency at the time. I don't know if they, you know, if they left money on the table, if they chose the wrong cases. I know one thing that comes up a lot is, you know, they've spent a lot of time on the meat packing industry, these other things. There is an argument to be made that those like Section 1 violations are more harmful to consumers, but there are these big-ish picture issues too. So it's hard to say. I'm in favor of stronger enforcement in any area that we can. And I think there are actually a lot of issues that need to be solved when it comes to agency jurisdiction and efficiency. And I don't mean to imply that antitrust law is perfect as it is. It certainly isn't. But we did find a way that was clear. And that brings me to kind of the last thing is the consumer welfare standard. The question that I'm asked a lot is, how do you apply the consumer welfare standard in an industry where it's a zero cost product? And the consumer welfare standard narrowly covers a bit more than that. The Microsoft case is actually a great example of that. And I think the DOJ was in the right actually in that case. But it does cover other factors such as innovation. And it's not about price effects alone, and it's not about, you know, those monopoly profits, what they're used for. I think that's a great point. And if they're used to maintain their monopoly in a legal way, that should be enforced under our current antitrust laws. And they can also be using it in ways that are violations of other laws. Some use it in ways that violate intellectual property. A lot of tech companies have done that. So that's one area. But I think that's overall a broader point. Sometimes it's an antitrust point, sometimes it's not. So that's kind of all I'm saying in response. Sorry, I don't want to be too long there.
Yeah, I guess we can start with the first question.
Before we do that, there's food up here for any folks that came in. You are not going to offend anybody sitting here at the head table if you come down and get a bite to eat.
Yeah, go ahead. Yeah.
That's it. It's for you.
Yeah.
Feel free.
I think we got one.
Yeah. Now that I mentioned
Yeah.
it, nobody wants to do it. I'm not walking up there now.
I'll take a few after this.
Yeah. Okay. All
We're
right.
not gonna get
Or you
to
can
you.
We won't ruin lunch by talking about recent suits in the poultry industry.
Okay, yeah, so first question, what is the scope of the government's cases against Facebook and Google, and what do they allege, especially in terms of anti-competitive conduct? And will these affect future cases or antitrust law more generally?
Which would you like to go first?
All right, first.
So I'll just focus on Facebook quickly. There are a lot of other suits against Google, and it makes more sense. So the Facebook case, it's based on its acquisitions, particularly of WhatsApp and Instagram. There's this underlying theory that's called killer acquisitions, that companies are essentially scooping up all of these competitors, and sometimes they'll work out, sometimes they won't, and sometimes it becomes Instagram. I would note that at the time that Facebook acquired Instagram, it was considered a bit laughable. So if it is a strategy, it's not necessarily a particularly good one. My main problem with the Facebook case, and I am, is particularly in the Google cases and in the other case, I don't comment really on, what the outcome might be. I haven't seen all the documents. These things are sold in discovery. There could be anti-competitive behavior there. Maybe there's not. I don't know. But my concern with the Facebook case is that we are unwinding a consummated merger. And that creates a lot of uncertainty for firms, for entrepreneurs as well. I've done a lot of these FedTech events and a lot of other events over the past year on antitrust, and I've been surprised by how many people who have came up to me afterwards and said, I had this great startup idea, but I actually was thinking of selling it as an exit strategy. And I don't think, the government should come in and say, your only exit strategy is to fight your opponent to the death. And that's not necessarily what they're saying, that they don't have the resources to challenge every single one of these, but that's a possibility. And that goes into how these people think and how VCs think as well. You can look at data regarding how venture capital withdrew out of the European Union following the privacy directive of 2002. And VC now, I know there's a lot of people in the startup community that kind of are a bit worried about where this is headed.
So a couple of additional comments to Ashley's helpful comments here. In October 2020, Department of Justice filed a civil lawsuit against Google, claiming that Google controlled 90% of the search engine market, and the search advertising market. These are two, obviously, they're kind of complementary products, they're kind of connected, right? And that they had considerable market dominance in that market. There's other evidence to suggest that Google's market share, at least in the search engine market, is closer to maybe 65%, not 90%. But I don't want to quibble with numbers because 65% is a lot. One thing that Ashley had mentioned that's absolutely true, the antitrust laws do not prohibit or make illegal being a monopolist.
Mm-hmm.
The statute, section 2, is framed in a verb tense. So you have to achieve a monopoly. You have to use any competitive or exclusionary conduct, which dozens, hundreds of U.S. Supreme, not hundreds, but dozens of U.S. Supreme Court cases looking at the conduct that is prohibited by section 2, that is affirmed with market power, dominance, monopoly status. 65% of the market, 70%, certainly 90% of the market. Market share is a rough estimate of market power. And the antitrust laws are concerned about power in the market and how you use them. So, so merely having 90% of the market for Google doesn't make it illegal. The key is the ability of the government to show that Google achieved or maintained that market dominance through anti-competitive or exclusionary conduct. Facebook, and the biggest problem with, as Kelly was pointing out, the biggest problem with the Facebook case, the Federal Trade Commission suit, which was filed in December of 2020, is it's already been dismissed. Motion to dismiss against the government's case was granted by the Federal District Court in DC. Court gave the government a chance to recast its pleadings. Basically, the Federal District Court said, well, government, you're bringing this on the theory of a monopoly. What market, properly constituted defined market, has Facebook allegedly monopolized? So on one hand, you have people who say, what does Facebook do? What does Facebook do? Social media. What is social media? Social media, as I understand it, is a plethora of different activities and businesses and looks and this sort of thing. No, they have to come up with a much more narrow kind of definition of the market that Facebook has monopolized. And they were unsuccessful of that in their pleading. So now they have another chance, another bite at the apple, according to the Federal District Court in that case. So their case initially, the Federal Trade Commission's case, was for illegal monopolistic practices, such as, and they're seeking a permanent injunction. And a lot of it came from trying to integrate apps. And a lot of their acquisition, go ahead to Wikipedia, for example, and plug in their Facebook acquisitions. Do the same thing for Google. And what you see are records of hundreds, not dozens, hundreds of acquisitions over the last 10-year period of time. They buy products, they buy know-how, they buy IP, that's what they do, right? That's their business plan.
I have a quick reading recommendation for y'all in the on the topic of why being a monopoly itself is not inherently illegal. If you, I would recommend reading either Justice Scalia's opinion in Verizon Wireless versus Trinco, or more recently the opinion in FTC versus Qualcomm, a case in which actually gets to the heart really of some of the inefficiencies we have in enforcing antitrust law. And we had two government agencies litigating against each other for 4.5 years. That shouldn't happen. Regarding the acquisitions, I mean, we don't quite have enough time to get into that. I think some of that's natural growth, but we'll see as the case progresses.
Yeah, another question. So you're talking about monopolies. So what are your views on monopolies? Like, are they legal or illegal? And what is the difference between actions that violate Section 1 and 2 of the Sherman Act for size or market dominance? Ashley, you can start.
Why don't Professor Polden, why don't you talk about the difference of 1 and 2? I could cover 2. I think, you know, you teach antitrust. I feel like you have the more succinct answer to that.
Yeah, Section 1 was intended to get to joint action. It was really designed for cartels. It prohibits agreements. Agreements mean more than one person, right? So that's the territory that Section 1 covers, collaborative action that restrains trade. Section 2 is about a monopoly, which is really kind of geared to single firm conduct. So that's the principal nomenclature between Section 1 and Section 2.
And I would add that in terms of reading cases, in these cases, for example, the case against Google, is interesting that they filed it as a Section 2 cases. Some of the arguments they're making are, it involves collusion with Apple. So it's always interesting to look first and see, you know, what statute they file it under, because sometimes it's more recently that there have been some surprises there.
And so what are some of the remedies that have been proposed by Congress? I know there's been a number of House bills. Can you discuss those?
Sure. So the House bills, they are all over the place. There are 2 bills in the Senate that are viable, that are not companions to this. The House bills are a package of 6 bills. I would say 4 of the 6 bills are very bad for different reasons. The simplest reason being just sloppy drafting. The one on data portability, for example, it's from a technical standpoint, it makes no sense. It, you know, leaves it up to the FTC to decide the definition of data 6 months after the law is enacted. So, you know, it's kind of pass it and, you know, see what it is. And the one that bothers me probably the most regards mergers and acquisitions, and flipping the burden of proof, among other kind of bright line rules. So first, all 6 of these bills in the package, well, 4 of the 6, these other 2 are a little bit different. One's about funding and one is about venues of state AG suits. But the other 4, if you look at, you always have to look at the covered entities first when you're reading legislation. What I do when I look for the covered entities in these tech cases is, I think, one, who could accidentally be swept up in this? Because these bills they're not directed at the industry specifically. They might have, the definition might specifically fit the industry, and is tailored towards that, but they can't say, you know, this is towards Microsoft, Google, and Facebook, for a lot of reasons. So it's based on market cap and a lot of other issues that it could eventually sweep up some other companies, such as Target, for example, operates an online platform that sells third-party goods and could eventually be swept up in this. A lot of people in the financial services industry, MasterCard, those sorts of companies. And what you don't want is the covered entities to be outside of that industry and who you specifically you're targeting. And by the way, the people who have concerns about speech, like Twitter is not a covered entity under any of these bills. That's something that's not really emphasized enough, is it would not affect them whatsoever. And this is the right vehicle for Twitter's problems, which they're a relatively small platform, by the way. So that's always interesting. And the second thing I look for is carve-outs. There are always carve-outs, and there are carve-outs of other tech groups like Microsoft did this in some of these bills. So there's the mergers and acquisitions, and it kind of is not quite an outright ban on M&A, but it does shift the burden of proof from the prosecution to the defendant. And I think, first of all, that more fundamentally goes against our system of the rule of law in the US. Whoever's bringing the charges has the burden of proof because they're bringing the charges. I mean, in most other areas. And that makes sense. And that's a great safeguard. If you also look at statistically, first of all, there's no good basis for that because the government's having no trouble winning when they do bring these cases. As Professor Polden was pointing out, maybe they should have been forced in more cases, but when they do, their win rate is still over 85%. Shifting the burden of proof to the defendant is extremely hard. There's only, I believe, one case ever that's been litigated in which a defendant has actually won on an efficiencies defense, which is what you would have to do in these cases. And also, there would be a problem of, on one hand, companies have to keep track of their efficiencies, and on the other hand, the government doesn't really have to keep track of anything. So they don't have to keep track of anti-competitive conduct and other things that they would usually do. So that one's very imbalanced. There's one involving lines of business, for example, Amazon selling their own products in the platform. I think there may be some valid arguments to be made regarding intellectual property rights and those not being enforced in that scenario, and maybe a couple of other areas of law and maybe some contract issues. But how is that any different than walking into a CVS or walking into a Costco? I mean, you have CVS brand vitamins first, you have Costco, you have Kirkland, stuff all over the way, and they all over the place. But they have a massive amount of data as well. The fact that these large wholesale distributors have a lot of data is not really anything new. They may have access to it in some specific ways that they shouldn't, but if they shouldn't have access to it, that's a whole other problem. So it's hard to cover all of the bills. I can drop in my explainer of all 6 of them in the chat box if you'd like.
Yeah, that'd be great.
Just a couple of quick comments. First of all, the antitrust laws that we have today are not up to the task of taking on big tech. It's too sophisticated in industry, and they have a head start. Google, Facebook, Amazon have been litigating antitrust claims in the European Union for 15 years. They're paying modest fines, 8 billion here, 5 billion there. That's less than half a day's revenues for these companies. And they're winning some cases too. So what they have is they have this juggernaut of lawyers and lobbyists that have been working for 15 years on this very topic. And so now, finally, the US antitrust enforcers jump in and they say, well, we're going to throw a bunch of resources and come at them on this. Well, I think somebody's lunch is going to be eaten. And if I had to guess today, this is based on today, it's not going to be Facebook or Google's lunch that's being taken. The bills, so my point here is, if the United States really wants to regulate tech, our antitrust laws are really not up for it. So we need new ones. And we need antitrust laws that are designed to have a single solitary purpose behind the laws, not political and economic and controlling bigness and this sort of thing, really a focus, especially on the tech industry. That requires agreement on what the problems are. In the Senate, 2 Republican senators, Holly and Mike Lee, have sponsored bills that are sprawling bills. They, want to get rid of the FTC and move all the money and the personnel over to DOJ. And, there's some grudge settling in some of this. Over in the House, it's even crazier. They got 5 bills, and it reads like the progressives' smorgasbord or wish list here in terms of what they want to get to. So looking at all of these bills swirling out there, I don't see any political consensus, and obviously we have very little leadership in the Senate or the House, maybe individually, but not in terms of a political movement towards we have a problem with tech markets and industries and we have to come together to solve it. I don't see that political will there. Although, as Ashley, I'm sure would agree, it's been marvelous. It's been interesting that there's such bipartisan support on so few things, except on let's hammer big tech. Let's get after big tech. And there's a lot of reasons why it should be. Antitrust is a form of regulation. It doesn't have a command central sort of things, but antitrust is about regulating markets and industries. Only here you have federal judges doing it in the context of litigation. That's a tough mix. Litigation is really not set up to get to big policy issues. Whether you were negligent driving your car, yeah, we can get to that. We get witnesses to get that done. But making policy decisions and litigation is very complicated. And if we have time to get to it, I can identify what I think are some of the most significant headwinds that the federal antitrust enforcers are going to face in the cases against Google and Facebook.
Can I first make a 1 minute response? So tech companies are winning, and particularly against private litigants sometimes, but that does bring me to a point, and this is maybe it used to not be an unorthodox position within really anyone in antitrust. Now there's some conservatives, I think, because they're defending Apple, who don't like this, but I would be in support of overriding Illinois BRIC. Of giving consumer standing, and that's not a cure-all for all of these problems. And you identified another one too, is regarding litigation. It does take a long time to bring these cases through the courts, and that's a long time waiting. And by the time there's a verdict, a lot of the times that, especially when it's brought by the government, the problem's already been solved. I do think you got back to the main point really well, is we do need a primary focus. It can't be 10 different focuses. I actually wrote an article recently with that. It's a blog series that's back and forth with me and Richard Epstein, and I have a paragraph or two in which I hyperlink to all the different left-leaning causes that people have pointed to antitrust to supposedly cure. Is partially a resource myself, so I had all those links in the same place. But I can send that around as an example. But the point that we are getting to too is there has to be a guiding principle, and maybe over the years people don't agree on what that principle is. But it's very important that we have something that's predictable and tractable.
Yeah, we have a number of questions, but yeah, we can do audience questions.
Yeah, I did have a question. So, you both mentioned that antitrust might not be a good fit for big tech, and I completely agree with that because, like you alluded to earlier, it's free. They benefit from network effects, right? It's almost to the extent that they're monopolists. Big tech companies are good because it costs nothing to visit a website. You'll visit the best version of the website that you want to go to. But in my opinion, the problem isn't so much the concentration or the scale of the companies, it's the speech concerns. I think that they haphazardly, to say the least, apply their terms of service and rules. And so that leads me to my question, which is, do you think maybe we could look at alternative things like Clarence Thomas's recommendation to treat them as utilities?
So I'd say that's definitely not something we can fit in 10 minutes. I'm not, for example, a Section 230 expert. I find it kind of unfortunate that's built into antitrust. I'm skeptical about any of the proposals that I've seen so far actually solving that problem. You do have to have a right of action, and conservatives are not a protected class. I don't see that actually being that beneficial in any way. Common carrier regulations have a lot of drawbacks as well. And it really does kind of entrench those companies and solidify their dominance and make sure that they're major players for a while. And that's really the most heavy-handed of all of that. But I agree with your point that sometimes these contracts are not being applied fairly. And that's one thing that I say a lot is a lot of issues are contract issues. No one really wants to go through and talk about contracts and contract law, but a lot of it is perhaps a contract issue.
If I could go back one more time, I think
Mhm.
on the subject of treating them like monopolies and the risk of entrenching their power, I think they're very entrenched and they benefit from network effects in much the same way as an electric utility does. And I want them to be more like an electric utility in the sense that they can't turn off your power for being conservative.
Yeah, so an alternative to antitrust regulation is public utility regulation. And that has been unpopular, certainly in Republican administrations over the last several decades. We don't need more regulation, government imposed, let the free market work, et cetera, et cetera. And so there's a largely a political clash in that, but it works. I mean, if you look at what public utilities do, you can superimpose that model on the tech industry, and essentially, I think the reorientation of the industry would be no more dramatic and wrenching to the industry than it would a divestiture order in an antitrust case, for example. So, but assuming that that's not a direction that you want to go to, and recognizing that big isn't necessarily bad, you have to figure out what the bad conduct is, and what you're going to do about it. One of the major problems in the potential remedy here, so these actions are not being brought, they're based on investigations where most of the evidence has come from competitors or wannabe competitors, to Facebook and Google and this sort of Spotify, what have you. So that they want some of what the dominant firms, Google and Facebook, for example, have built, principally their advertising business. So what they want a government remedy is a duty to share as a remedy. And Justice Scalia, very conservative antitrust guy, might add, pointed out that the antitrust laws do, in limited circumstance, recognize as a remedy a duty to share between a dominant firm and a wannabe, want to come in and build it. But he was very skeptical that this is a significant and useful kind of remedial concept in antitrust cases. He said, but we are very cautious because of the uncertain virtues of forced sharing. So that is the heart of these cases, I think, on the part of competitors who now want to get in, and they want to get it into the advertising business. And the practices that the company has had have been focused on the building of their own product and services.
I think that we got, oh, sorry, go ahead.
No, I was just going to briefly say that look at their business plan. I mean, this is not a stealth antitrust issue. Years ago, we got on a search engine. I want to take a vacation in Cancun. The next day, I start getting ads directed at me for restaurants in Cancun. And you think, how did this happen? Well, it became pretty obvious to us what was happening with this. One of the concerns, antitrust concern, is the gathering of this data, the monetizing of it by these companies. That's where most of the revenues come from. It's not from your free search service. So how are we going to control that, limit that, create more competition in these markets, other than by implementing a forced duty on Google to help your competitor? This is take your competitor to Workday, and you, I'm being a little facetious, you got it. And so you do that to help them to break into the market. Is that a viable pattern for development of that industry?
I was making, this side remark that I really hate that with 5 minutes ago we got into my favorite antitrust topic, which is duty to deal. It's sometimes we don't get nearly there. I have a lot of problems with that, and I think the statutory basis, or sorry, the basis in case law is very much stretched, particularly in like Judge Koh's opinion in the Qualcomm case, but also as Scalia pointed out decades ago. I don't think it's really based in the law. I have problems with that from just a basic property rights issue. As Abraham Lincoln, who said, the man who grows the corn should be the person who eats it. That broader concept, I think is really important. And, between, a middle ground between that and, public utilities. And this is idea I think that's not really been very well developed, at least not by me and not by anything that I've seen, but there could be a contract law solution. There could be a FRAN type framework to superimpose on current law that could help with the access problem. But I do agree that particularly the further down the stack you go, when it comes to, AWS and others, the more concerning that really is.
Any other audience questions?
We reserved all the 2 minutes here to explain.
First of all, I want to begin by thanking those for the time and review. On the Facebook point and the FTC, I wrote an article for the Advocate in the spring. I interviewed Professor Polden for that. And one question
Did I have the same story today as I gave you last year?
Here we are again.
Yeah, okay.
I did get one question from a peer, especially after the amended complaint by the FTC last month, about, we talked about the Sherman Act, Section 2. Essentially the question is, if Facebook internally, Zuckerberg said things like, it is better to buy than compete, and that's on the record, it seems like a slam dunk case of monopolistic practices based on their acquisition of WhatsApp and Instagram. In your opinion, maybe, it could be a brief answer, but does that seem like a monopolistic practice, and should they be subjected to, this kind of lawsuit that the FTC is bringing under their authority?
Well, what I did, I represented plaintiffs for a while in antitrust cases, and I used to love getting those sound bites in a memo from the CEO of the company. It's a gotcha. But the antitrust courts anymore, they say, we're interested in the economic impact of transactions in business and activities. We're not interested in a comment. Sometimes the comments can indicate that the purpose of the action was to fix prices or some other competitive behavior. So those kind of gotchas, if FTC gets in front of a jury, you might want to spring that out. Because I'll tell you, Google and Facebook are going to do really well in front of a jury. They are going to do really well in front of a jury. You all know it. I mean, it's free. It's good service. And now, why are we looking at this anti-competitive lawsuit against these large entities that we use day to day? So what the jurors are likely to say is that this is they would use these terms. This is kind of a consumer protection issue more than it is an industry competition, failure of competition, or monopolization problem.
And those emails and remarks, they call them hot docs, you see in congressional hearings and using a lot of in court, that can't be used as any sort of single determining factor. It's can certainly play into things, but that in and of itself isn't dispositive. It doesn't help the companies, though, that they have been talking like they're all members of the mafia or something via email. That was not exactly wise.
Any closing remarks, or now it's 1 o'clock, so we got to wrap it up.
I have the last one here. This is all going to be on you. You're going to be setting antitrust policy. You're going to be figuring out what is a good issue in an antitrust case and bring it. And you're right here in the home of all of this, where you are these tech companies, these defendants. And so tremendous opportunities to get involved in antitrust work in the Valley. And I hope you look for those opportunities with law firms, government enforcement agencies, because they're all ramping up. They're looking at, these cases go for decades. They don't go for months, they go for decades. So could be a full employment act for you. Enjoy it.
Thank you.